thank you for having me, and good morning, everyone. So, Toyib have asked me to talk about intellectual property concerns for SMEs. And basically, when you talk about IP, what I've noticed in Nigeria is that most SMEs or entrepreneurs don't take intellectual property seriously. IP is supposed to be considered to be your intangible assets and your long-term goals for your business. So if you're starting a business and you hope to live as long as the Microsofts and the Amazons and all the other companies from the Western region, it's best that you consider IP as one of your portfolios or strategies to live in long term. So I'll start by sharing my screen, and can you disable so I can share? Okay, so before he does that, let me just continue. So what I'll be talking about today is what is IP. So when I say IP, I mean intellectual property.
You can share your screen. You can share your screen, Rita.
IP.
You can share now.
Okay, great. Oh, it says host disabled participant from sharing screen.
Oh, really? Okay, yes, you can share now.
Okay, so my outline, what is IP, what are the types of IP, before taking your ideas to the market, what are things you need to consider IP-wise, what's the importance of IP for SMEs, then the concerns I'm going to be addressing that, then how do you resolve intellectual property dispute related to SMEs, and we will conclude from there. So my own definition of IP is that, SMEs are considered to be the backbone of an economy, and that contributes to the GDP of a country. So yesterday we had an event where we talked on IP and the economy. How are they intertwined? What are the benefits of IP to an economy? And one of the things that one of the mentors talked about was he did give us data as to how IP contributes to growth of an economy. However, what we've seen, or from the stats that was given, we don't have much contributors when it comes to IP globally. We don't have people registering their patents or trademarking their products or their businesses, or focusing on the goodwill, or even looking at how the consumers can contribute to the growth of their business. Everyone is focused on funding and just creating product and putting it out there. So we also had an event in Port Harcourt. So I stay in Port Harcourt. So we know that the startup bill has been put out there for, I think, 2 months now. We had a stakeholders meeting in Port Harcourt. Now, during one of the sessions, we had a tech founder. So he was making comments as regards one of the provisions, which stated that startups and SMEs would have a one-stop shop where they can do all their registrations, including intellectual property. And he goes to say, why do I need to do an IP registration when I can just launch my product? If it doesn't work, then I move on to the next one. For that, butchering his point, he said they had these ethical codes where you build your product, put it out there. If it works for you, fine. If it doesn't work for you, you go on to the next one. And then we've seen live cases where even when startups or entrepreneurs create a product or put it out there and it doesn't really work out for them, at the end of the day, they end up selling that. That's one of the benefits of IP. You can actually commercialize or monetize your business at the end of the day. So my definition of intellectual property is, so the IP is an intangible assets. So we have tangible and tangible assets. Intangible assets because you can't really see it. What we can see are your finished products. So it has to be in a tangible form at the end of the day, whether it's a book or a story, a movie, a song, a car, a chair, whatever it is, we have to see. So before you put it in that form, all you have are just your ideas. And IP basically does not protect your ideas. It has to be expressed into a tangible form. So you have copyright, trademark, patent, industrial design, trade secret, which are very important for SMEs. The other forms of IPs are more economically based. So you have the plant varieties, you have geographical indications. And that's, I do consider those form of IP to be not too popular. They're not popular because SMEs do not consider the GI aspect of their product. So if you make, so I know someone makes what's it called now, a converted, push that out into the market. That's supposed to be putting your product on the market and putting Nigeria on the map. So if anyone asks for that particular brand, they're like, oh, this comes from Nigeria. That's a form of GI. So if we are exporting our product out, they were also putting our country on the map and also telling the world that we actually know what IP is and we're exploiting all aspects. We're not leaving it for anyone to take advantage of it. It also gives the owner the exclusive rights attached to the work from the creation of your mind. You also get to enjoy legal backing and protection where you eventually register your work. So IPs like trademark. So we have the registered and unregistered trademark, and you also have service marks. Now, unregistered trademark means that even if you've been using, say, your brand name, your logo, your slogan, catchphrase, anything affiliated with your brand, and you haven't registered it, but you've been doing that consistently so under the Nigerian law, it's about 5 years, you can actually sue someone who decides to use your business name. So we have to understand that SMEs is different between CAC registration and IP registration. I think that's where a lot of people get confusion. But one of these registration gives you an upper hand at the end of the day, which you have to pay for. Another for me to tell you. IP is also territorial in nature, and you must use it to make money. It has to be for commercial purpose. So you can't just say, oh, I have a book, and you just keep your manuscript there. You're not making money for it, it's just there. So if someone decides to steal it and decides to monetize it, and you cry, well, what have you done to actually protect yourself as an SME? Now, the forms of IP. First, I will talk about copyright. Copyright, basically, the long and short of it is copyrights are artistic and literary work. So it could be your books, softwares, cinematograph work, broadcast, audio visuals, pictures, sculptures, architectural works, anything that is in writing or anything that we can see, listen to. Those are eligible works under Nigerian copyright law. So for SME, one thing we need to know when you're dealing with IP territorial, which I stated earlier. So if you now decide to branch out to say Ghana, you have to comply with the Ghana rules. You won't still be relying on the Nigerian rules. Then you have trademark. Trademark basically could be any name, sign, symbol, figures, smell, which are considered to be very uncommon because it's also hard to protect. Then you have sounds as well. Then you have numbers, phrases, slogans. Now, copyright doesn't protect titles or short phrases for a very obvious reason. It's considered to not be original and authentic. And one of the benefits of copywriting your work is that from the moment you create your work, it enjoys automatic protection. However, in Nigeria, the Nigerian Copyright Commission advises people to deposit a copy with them for future purpose. So if in case someone decides to use your work, you can also use that as reference, like, okay, I have a copy with the NCC. Whereas in the United States, it's a requirement for you to actually register your copyrighted work before you can actually sue for infringement. So if you don't do that, then you don't have the rights to actually sue someone for infringement. We do have defenses for using someone's work without their consent. In Nigeria, it's called fair dealing. In the US and the UK, it's called fair use. So another form of IP that SMEs should take note of is patent. Patents are basically inventions. So your cars are full of patent work. Your phone, the laptop you're using to listen to this event, or the phone you're using to listen to this event, anything that is an improvement of an already existing product. So you see that you have a lot of cars out there. There's always another model and another model. The same thing with our phones. So I know when iPhone 13 came out, there's a lot of buzz as to people saying there's still difference between 11, 12, and 13. But when it has to do with the IP aspect, is the functionality. That means what is that thing that makes it new, or what is that tiny bit that makes it different from iPhone 11 or iPhone 12 or iPhone 13. Same thing, the software can be patented. You also have to show that it's not obvious to a regular person or a skilled person. So if I look at your phone or I look at your product, can I be able to replicate it? If it's easy, that means it's not new. And you must meet the basic requirements of it being new. there's no prior art existing out there. Whereas for trademark, you must show that it's very unique. So it must meet the distinctiveness test at the end of the day. If it's not distinctive enough, that means it's too generic. Generic means any regular words that anyone can use. So we know you want to buy detergent in Nigeria. Everyone calls all the brands of detergent Omo. Why is that? So that means Omo as a brand has become very generic. The viral we use is a trademark, but because everyone calls up pen, I want to buy biro, I want to buy a pen. Same thing with your tablet. Then you have trade secret or confidential information. This is what gives your business an edge over another person. What is that thing that you feel if your competitor or someone else should hear it, it's going to have an effect on your business? So essentially, it involves you controlling who has access to that information. You also impose a legal duty on that person that they should not disclose whatever information was given to them. So one of the most guarded trade secrets in the world is the Coca-Cola recipe. It's been, a lot of people have tried to replicate it, but they've not been able to get that exact recipe. Now, there's a story that we're always told in IP classes that the people who have the recipe don't always travel together. They always have to be on separate flights, which means if one person dies, the recipe is protected. So that everyone takes confidentiality very serious, and that's something that I feel SMEs do not take seriously. They're just too nonchalant about it. That you're not you employ people and you share information with them that you feel that's supposed to be confidential to your business, but then you don't document it. Did you sign any employment agreement with them? Does your employment agreement have a non-disclosure clause? So there's a difference when you include a non-disclosure clause in your employment contract and when you draft a separate non-disclosure agreement. And that's something that I feel SMEs are always mistaken. So you always get requests like, oh, I need an NDA, and I'm asking you, what do you need an NDA for? And like, oh, I'm going to pitch to this business person and I need him to sign that. So I'm an investor. Why are you coercing me to sign an NDA when you haven't shown me that your business is actually going to give me good return of investment at the end of the day? So if I don't see something valuable in your business, I don't see the need why I should be signing an NDA. And that's something that, why I do advise people is that before you pitch that, I prefer you go and do your IP registration. So at the end of the day, when you pitch and they don't get back to you and they decide to take your product and reproduce it into theirs, you cannot have a ground for suing that, oh, you actually came up with this first, and you can show proof that you actually own that product. I know that we've seen a lot of social media collab where someone is like, I've gone to pitch this, or I sold this and this person sold this from me. So those are the issues. Then one of my favorite is industrial design, which focuses on the look and feel of your product. So it could be the chair you created, the bottles, let's see now. So anything that once people see it, it can attract them to buy your product. The visual appearance of that product, is it the color combination, is it the lines or whatever? So under the Nigerian Patent and Industrial Act, it says industrial design could be a combination of lines, 2 or 3 lines, or a combination of colors. So I know in the fashion industry, Diola said when she registered the design of her Komole Ashoke, she put out an IP notice stating that anyone who tries to imitate her work will be sued for infringement. I saw that as a good, thing. So that's something that we need to also consider as SMEs. Now, before taking your ideas to the market. Now, one of the intellectual property organizations known as World Intellectual Property Organization usually celebrates this annual World IP Day every 26th of April. And the theme for this year was taking IP SMEs, taking your ideas to the market. What are the things you need to do before you put your product out there in the market? And it's a global event that takes place everywhere. So if you're going to be having an event on 26th of April, it's either you collaborate with WIPO or you just ping your activity map that they always put out there. So I wrote in line with the World IP Day. WIPO chose the theme for this year being IP and SMEs, taking your ideas to business, because every business starts with an idea, and that is true. So you sit down, you have this thing going on in your head, and you feel you have to convert it into something. And it must be converted into a tangible form. What are we seeing? Your logos, your brand name, the products you've created, whether it's perfumes or bags. So there's this lady I recently followed on Instagram because of how creative her works are. She knits her handbags. So her bags are hand knitted. And I found that really fascinating. And I'm asking myself, has she done the IP registration for this? I guess not. But because now TikTok is helping business owners like projecting their product, making them visible and all of that, she's not thinking of the IP as all she's thinking about is getting customers at the end of the day. So far as she can sell 100 pieces in a month or in a week, that's her main focus. But if she's looking at it from the IP aspect, what she would do is to protect the designs of her handmade bag, protect any, so let's say, so she can also patent how she makes that bag. She can also copyright how the bags are made. She can trademark the name of her brand. So you see that one product already gives you 4 intellectual property rights at the end of the day. So that's another thing that I think SMEs should also take cognizance of. Now, as an IP owner, you need to be proactive by being committed to your creation and innovation through registration of your work. You need to also identify the strategy for the success of your product IP-wise. Are you looking into long-term goals? What are your long-term goals for your product? Do you want to have a big franchise at the end of the day in your sector? So IP basically interfaces with every sector. So every sector has an element of IP, whether or not we agree. There's an element of IP in your work, from the name to the product you use and the things you write and the rest of it. Now, SMEs should also speak to their intellectual property law. So there's a difference when you speak to a regular lawyer or a generalist, a lawyer who does everything. And when you speak to a specialized IP lawyer, he advises you, other than doing your CAC registration, on what you can do IP-wise, what are the intellectual property rights that you get to own from your product. They also help you to do due diligence in terms of investigating chain of title when using an IP that doesn't belong to you. So let's say you're an advertising company or a PR company, and you need to create an advert for someone, and you need to use certain songs, pictures, videos, and all of those things, products and the rest of it. Now you have to start tracing who owns these things that you want to use. The people that are working with you, did they create it from was it from the scratch, or they had to use elements of other people's work at the end of the day? So those are things you need to consider. If they did not do that, then you have to reach out to the owners, get their consent, get their permission, get the authorization in writing. No oral agreement when it comes to IP. It has to be in writing. It has to be properly documented. Then you also need to know the difference between a work for hire and a work created in the course of employment. So I know 2020, we had a lot of cases where people were like, oh, I used to work in this company and I created this product, and now my company doesn't want to give me my products. They are stealing my intellectual property right. What does your employment contract say? What does the IP clause in your employment say? Does it say that any work you created in the course of your employment belongs to you or belongs to the company? So if you're not looking out for that, if you're not having someone vet your employment agreement, those are the issues you're going to have. So there's this case called Please Call Me. I know in the early 20s when mobile phones came into Nigeria, there are a lot of Please Call Me back that were going around. Now someone in, what's the country now? I can't remember. But there's this guy who used to work for T-Mobile. And because he had communication issues, he was always running out of airtime while talking to his girlfriend at that time. He's married to her now. So he came up with this idea of creating a short code that if someone needs to talk to you, they can just send you that message, please call me. And that was done while he was employed at T-Mobile. But his contract has said that he can create products and own them. So he reached out to his employers and told them, this is my idea. This is what I want to do. And they bought into his idea. They even did a what's it called now? They did a publication about it, commending him for his effort, and they went into a licensing arrangement. But at the end of the day, the employer decided to turn around and, started saying, oh, he was our employee, he did this while he was working with us, and he went to court, and the court was in his favor. Now, the issue now is that, so for the IPs, you have various terms of protection, duration of protection. For patents, is 20 years, and what he created was patent work. And patent work is 20 years. That case is 23 years today. And what the court has said that they should calculate the royalties that were meant from him from the day he created the work up until when the case was still in court. And suggested a figure, but the employer refused to pay. So he was asking, so it's a South African case, yeah. So he was asking for about 10 billion rands, and they offered him, is it 10 million rand? And he said that's not true, that he can't take that because he knows his product is not what they were offering him. So they are still in court, and we're waiting for judgment, hoping that at the end of the day he wins. But then I looked at it from a very controversial aspect, where I saw it as a delay tactics from the employers, waiting for his term of duration to expire before they actually pay anything and say, okay, now you don't want the IP in this, we're not supposed to pay that. But that's just me, looking at it from another aspect. Now you also have to learn about technological breakthrough. So let me explain the work for hire. So you commission someone to do a project for you. Did you sign a contract with them stating that after the project is done? That's specifically for developers. I see this a lot, where someone commissions you to do a software, you do it, and I ask you questions. Do you have a contract for the person developing your software? And I get no. And okay, I think this is what I think you should do to protect yourself. Tell him when he's done, you should transfer everything. Because there are times when developers want to hold certain aspect of the software, so you have to keep coming back to them. But if you have an arrangement with them, telling them, you have to give me everything. However, you can help me in maintaining this software or this app at the end of the day. So you have two separate contracts at the end of the day. Is my time almost up?
Yes, I know you have a lot.
Okay, so I'll be rounding up now. So let me just rush. So you also have to learn about recent tech breakthroughs. Know that you can use your IP to build stronger and more competitive and resilient businesses. Include IP in your proposal. That's something that I think most investors always look out for. If your IP is not valid and it's not included in your portfolio, that might, reduce the amount of money or capital you might want to get while raising funds. Then we'll be talking about the concerns. How IP can help businesses and SMEs. It can also boost your business financially by increasing its value. So you created a product today, and in the next 2 years, the value has risen up. So while you're going into a negotiation or a partnership or collaboration, once your product is valued, you have an upper hand at negotiating for a larger fee. You can also exploit or monetize or commercialize your IP. You can use it to position yourself strategically on the map. It's also a tool for development, and it also boosts the economy and gives you a competitive edge. I've already talked about that. Then importance of IP, I'm not going to really delve into that, but also basically it's almost the same thing. So there's an article by WIPO where they did a lot of reviews about people in Africa. So there's this guy who created the cardio pad that's used in one of the African countries to do EMGs and the rest of it. And it helped him while he was looking for investors. It was a major asset for him. He went as far as patenting what he had done and licensing it to different people. So licensing, you can do an exclusive license within one person. You can do a non-exclusive license with several other persons. Then the concerns, one, your brand name. So we had the case of Bentley Clothing against Bentley Motors. Now, because Bentley Motors is a big brand, Bentley thought that they could tramp on Bentley Clothing, who had been there since 1965. But at the end of the day, the court asked them to change the name of their clothing line, because Bentley was going into clothing, and Bentley Clothing had been there since 1965. So the court asked them to change their name and also destroy all clothing that had Bentley also written on their t-shirts and other products. They have the product game where you're so concerned about how the market or the consumers will accept your product when it's put out there, instead of and then you leave out the very important elements that makes your product standard. Then you have the market game where you see big brands wanting to take over or bully smaller brands. So last year we had the Prepare and Apple Inc. case, where Apple Inc. had to put up an opposition at the registry saying that the Prepare logo, which was a pear with the leaf on the left hand side, was similar to that. But then they got a lot of backlash from the public, and they changed that. Then the consumer game, where the consumers have the final say. The consumers are the ones that decide how your product will be perceived. Now we had the Booking.com case against the United States Patent Trademark Office, the trial board, where Booking.com claimed that their product was, if a consumer put Booking.com, they already saw it as a brand identity. They could always differentiate or know that, oh, this is for hotel bookings and accommodations. Whereas the registry said that it was not distinctive enough. But then at the end of the day, they ended up with, they have the funding gain. Is your IP included to give you more hand in terms of raising your capital? Then you have the domain name game, where you have cyber squatters who would register your business name because they know you're becoming famous, so that at the end of the day, they can throw you back and then try to get you to buy back your name. Then you have the pre and post market stage. One of the things that you're putting in place to make sure that before you take your ideas to the market, your IP, your strong IP wise, and the success of your product is guaranteed. Then you have the pre and post contract stage. Are you documenting your transactions before you take your ideas to the market and after you taking your ideas to the market? Then no, you don't need to wait till you become big or global before you register your IP. Then dealing with IP trolls. IP trolls basically are people who register business names waiting to benefit from your reputation and goodwill. The matters arising, issues on ownership and authorship, definition and eligibility as what can be protected, our addicted law, not investing in IP. Rounding up now, resolving IP dispute. There are two forms or two ways you can do that. One is by going to court, which is the Federal High Court, and then opting for alternative dispute resolution mechanism, which could be mediation, conciliation, negotiation, or arbitration. Then in conclusion, IP is not adequately appreciated here in Nigeria. It's best that SMEs consult their lawyers, best in IP, discuss their long-term goals, create an IP strategy. You also need to think big when it comes to intellectual property. Document all your creations and inventions. Know the difference between intellectual property and also intellectual property right. There's a difference, trust me. IP does not protect ideas. So you can't say this person stole my ideas. Where is your tangible form of what you created? Then you also need to know that IP is territorial in nature. Then take note of the IP protocol of the AFTA agreement. Please follow that conversation. And also follow the conversation in relation to the startup bills. And yeah, thank you.
Yes, Rita, thank you so much.